The Establishment Act answers the question as to how the United States Constitution requires the government to respond to non-secular, self-asserted sex-based identity narratives like homosexuality and transgenderism, and to sexual orientation orthodoxy. The bill is based on the following framework. The United States is a constitutional republic, which means the federal and state government cannot create or enforce policies that conflict with or violate the United States Constitution. Every member of the judicial, executive, and legislative branch are bound by oath pursuant to Article 6 of the United States Constitution to not create or enforce policies that violate the United States Constitution, regardless of their political affiliation and the desires of their constituent base. The Establishment Clause of the First Amendment of the United States Constitution states that the government shall create no law respecting the establishment of a religion. What this means in plain English is the government cannot cultivate policies that have the direct or symbolic effect of establishing one national religion that's mandated. The government is to remain neutral on matters of religion and not establish an official national religion. The Free Exercise Clause of the First Amendment prohibits the government from interfering with a person's belief in a particular religion and the practice of that religion, with some exceptions. The Establishment Act provides the legal definition for the term religion. All religion amounts to is a set of unproven answers to the greater questions like how did we get here, what should we be doing as humans, and what happens after death. A religion can be theistic, involving belief in God, or non-theistic, involving disbelief in God. The Establishment Clause of the First Amendment was never designed to just prohibit the government from respecting the edicts of institutionalized religions like Christianity and Judaism. The Establishment Clause was designed, if not more so, to prohibit the government from respecting the edicts and doctrines of non-institutionalized religions like secular humanism. Secular humanism is also referred to by scholars as Western postmodern individualistic moral relativism or expressive individualism. Secular humanism is the non-theistic faith-based belief that there are no moral absolutes and that man is God, putting man at the center of the universe. According to Secular Humanist Manifesto 1 and 2, secular humanism has many denominational sects. The evidence shows that Black Lives Matter, Parenthood Federation of America, and the LGBTQ cult are denominational sects of the religion of secular humanism. The LGBTQ cult meets the legal definition of a religion because it involves a closed system and a community that is full, organized, and has a private moral code by which its members can guide their daily lives by. Just as Christianity has the cross, Judaism has the Ten Commandments, and Islam has the star and crescent, the LGBTQ secular humanist cult has a rainbow-colored flag to represent their faith-based values. The Establishment Act is based off of sworn statements provided by ex-gays, medical experts, religious experts, and persecuted Christians, all of whom have testified under oath that there is no proof of a gay gene, that the idea that sexual orientation is predicated on immutability is not proven, but rather homosexuality, transgenderism, and sexual orientation are an orthodoxy, a doctrine, an ideology, a worldview that's inseparably linked to the religion of secular humanism. They are not a medical science or a benign philosophy, as many leftists pretend in order to gain personal political power. The United States Supreme Court, first in Torcaso versus Watkins, and then in subsequent cases, and just about all of the Federal Court of Appeals, have found that secular humanism is a religion for the purpose of the First Amendment Establishment Clause. The Establishment Act is predicated on the idea that when someone says that they were born gay, that they were born in the wrong body, or that they came out of an invisible closet and were baptized homosexual, those are a series of unproven faith-based assumptions and naked assertions that are implicitly religious and inseparably linked to the religion of secular humanism. Therefore, the Establishment Act states that the government is prohibited from creating or enforcing policies that promote, respect, favor, or endorse LGBTQ ideology or sexual orientation orthodoxy, because those policies fail the three prongs of the Lemon Test and therefore violate the Establishment Clause of the First Amendment. The Lemon Test is a three-pronged test created by the United States Supreme Court in Lemons versus Kurtzman and is used to determine whether or not government action violates the Establishment Clause of the First Amendment. The test requires that 1. A policy have a primary secular purpose, that 2. A policy not cultivate an indefensible legal weapon against non-observers of a religion, and 3. That a policy not excessively entangle the government with a particular religion. According to the United States Supreme Court, if government action fails one prong of Lemon, it's unconstitutional under the Establishment Clause. The Establishment Act reflects the fact that policies that promote, respect, endorse, and favor LGBTQ ideology and sexual orientation orthodoxy fail all three prongs of the Lemon Test by a landslide. For one, they constitute a non-secular sham that lacks a primary secular purpose, putting the religion of secular humanism over non-religion and over other religions. 2, those policies cultivate an indefensible legal weapon against non-observers of the religion of secular humanism. And 3, those policies tend to excessively entangle the government with the religion of secular humanism as advocated by the LGBTQ cult, which means that those policies always have been and always will be unconstitutional. This means that the Establishment Act invalidates any marriage policy that does not involve one man and one woman, any policy that prohibits conversion therapy, any policy that punishes discrimination on the basis of sexual orientation in the private sector, like the COTA statute in Colorado, which the Colorado Civil Rights Commission has used repeatedly to mercilessly persecute Jack Phillips under, any policy that would allow an individual to change their birth certificate, driver's license, or any other official government document that does not accord with the biological anatomy that they were born with, any policy that forced the private sector to allow biological males to use a female restroom based on their non-secular self-asserted sex-based identity narrative, any policy that forced a prison to house biological males with biological females based on their non-secular, self-asserted sex-based identity narrative, any policy that allows for taxpayer dollars to pay for sex reassignment surgery, any policy that requires a health provider or an insurer to cover or provide a procedure that respects transvestite dogma, any policy that mandates pronoun changes out of respect for the LGBTQ cult, any policy that would allow for a public school to teach or promote LGBTQ ideology, any policy at a public school that would allow biological male students to participate in an all-girls sports out of respect for their non-secular self-asserted sex-based identity narrative, any policy that allowed a public building to display the LGBTQ flag in a manner where it would be unlawful for the building to display the symbols of institutionalized religions, and any policy that would allow a public library or public elementary school to host and sponsor drag queen story time for children. All of those policies are unconstitutional pursuant to the First Amendment Establishment Clause. The Establishment Act permits taxpayers to bring a civil right of action against any state actor that continues to create or enforce policies that promote LGBTQ ideology. In a lawsuit brought under this act, a plaintiff can seek injunctive relief, attorney's fees, costs, and other forms of relief. A state actor who is a defendant in civil litigation brought under this act cannot raise sincerity of belief in LGBTQ ideology as a valid defense. This is because there's a long-standing jurisprudence that emotional appeals, even really good ones, cannot be used to usurp the Establishment Clause of the First Amendment of the United States Constitution. The Establishment Act makes clear that the government will continue to enforce man-woman marriage policies because man-woman marriage and man-woman marriage policies are natural, neutral, and non-controversial. They're secular in nature. They don't put religion over non-religion. They actually accomplish their intended purposes. They're not a political power play, a ploy, or a sham. Man-woman marriage policies do not erode community standards of decency. They don't promote licentiousness, and they're not an attempt to justify practices that are inconsistent with the peace and safety of the state. To eliminate any ambiguity, the Act defines secular marriage to mean a legal union that represents an intended lifelong commitment between one person who was born a biological male and one person who was born a biological female as husband and wife, who are of equal but opposite genders, who become spouses of the opposite sex, and who have corresponding sexual anatomy that, if coalesced, have the actual or symbolic potential to create offspring, who will likely have the input of the two spouses with whom they share the same genetic code and unbroken ancestral chain with. No other relationship on the planet is like that. And the fact that we have to go to that extent to define secular marriage is pretty outrageous. But many aspects of the left have become so intellectually dishonest that we don't want to give them any more wiggle room. And the government has compelling interest to set apart man-woman marriage for secular reasons. Under the Free Exercise Clause of the First Amendment, a person can still self-identify as a homosexual, they can still live that lifestyle, they can still have a wedding ceremony with a person of the same sex, they can still have transvestite surgeries, but the government cannot respect it, endorse it, promote it, or favor it. The government must not recognize the plausibility of non-secular self-asserted sex-based identity narratives or sexual orientation orthodoxy because they're religious doctrines. Every American should get behind the Establishment Act because it will restore the rule of law, restore constitutional supremacy, and stop the left from legislating immorality in a manner that has cultivated a dangerous cultural civil war.